Court of Appeals Division 1 is now in session.
Thank you. Welcome to the Court of Appeals. Please be seated. This is Committee for Justice and Fairness versus Arizona Secretary of State, etc. Case number CACV 13-0037. This is time set for oral argument. For the party's information, we have read the briefs, conferenced the case, and we have also viewed the video, the 30-second advertisement. Each party will have 20 minutes to make their argument. Appellant, you may reserve a portion of your time for a rebuttal, and if you would tell us how much time you want to reserve for rebuttal when you start your argument, we'll try not to horn in on your time. The podium has the amount of time you have remaining, and appellant, if it says you've got 10 minutes remaining and you want 5 minutes of rebuttal, that includes your 5 minutes of rebuttal. So the proceedings are being recorded, both audio and video, and hopefully, if all goes well, you'll be able to see yourselves on YouTube in a couple of weeks. So with that in mind, you may begin.
Good morning. My name is Colleen Connor, Deputy County Attorney on behalf of the Arizona Secretary of State and the Maricopa County Attorney. I'd like to reserve 5 minutes for rebuttal. May it please the Court. This case is about Arizona's campaign finance disclosure laws. It does not limit spending and it does not limit contributions. It's all about disclosure.
Does it limit speech?
It might have a limited burden on speech, but that goes to how onerous the reporting requirements actually are. And in Arizona, the reporting requirements are very simple. There's the registration, disclosure of the chairman, treasurer, name, address, disclosure of the financial institution, and then in this case, there would have been 2 campaign finance reports disclosing the contributors and how the money was spent, and then the 4th report would have just been a termination statement to close the account.
So it doesn't censor speech per se, but it may limit those who can speak based on disclosure requirements? Is that what you're saying?
Judge Jones, I'm not sure I understand what you mean with
Do you limit the
censorship.
topics? Do you limit the topics that can be discussed within the requirements?
Oh, no, by no means.
So the limitation is based in the requirement of disclosure. You're not censoring speech per se.
That's correct. There's no censorship of speech. The speech can include anything that the speaker wants to say. They can spend as much money as they want. They just need to tell the voters, the people viewing the television commercial in this case, who they are. So the Appellee Committee for Justice and Fairness challenges that the ad does not fall within the definition of express advocacy, ARS 16901.01. So I'll start with that. This ad is a general public communication broadcast on a television medium. There's no dispute about that. It was a television ad. Exhibit number 1 from the administrative hearing was from Channel 12, an NBC affiliate. So it was broadcast on at least one major network station that we know about. It referred to one or more clearly identified candidates, and pursuant to the definition of what is clearly identified candidate under ARS 16901.4, the ad would have to include either the name or photograph of the candidate. And in this ad, the name, Tom Horn or Superintendent Horn, is used 3 times.
Does it have to, excuse me, Counsel, does the ad have to identify the individual as an existing candidate?
Judge Winthrop, no, it does not. It just has to identify the name of the candidate or provide a photo of the candidate.
So their status as a candidate is something that's inferred from from common knowledge?
Judge Winthrop, it would be the viewer's perception of who that person was and whether they were running for office.
The reason I'm asking is this particular ad, of course, does not identify Mr. Horn as an existing candidate. It refers to his past service in the House of Representatives and his current status as a member of the Board of Education. I'm just trying to square that with the language in the statute that refers to a candidate.
Judge Winthrop, that's correct. This ad does not identify Tom Horn as a candidate for Attorney General, but under the magic words test, that's not required either, that the candidate be identified as running for a particular office. It's as long as the name or the photograph or the likeness of the candidate is used in the ad. Next,
The person must be a candidate. Is that correct?
yes, Judge Jones.
Doesn't have to refer to them as candidate Tom Horn in this case, or Tom Horn who is currently running for the Attorney General's office, or Tom Horn who is currently the Superintendent of Public Instruction.
That's correct. The name alone is sufficient.
Thank you.
The ad was targeted to the electorate of the candidate. It was broadcast statewide. The appellees say it was broadcast to impact people reporting something or calling the state superintendent of schools. That audience would be for a statewide office, the same audience for Attorney General, another statewide office.
The ad had a call to action in it.
Yes.
It was not a call that expressly directed the viewer to vote for the candidate or against the candidate, but it was a call to action nonetheless. Is that sufficient to constitute express advocacy?
Yes, Judge Winthrop, it is. The call to action was to call Tom Horn and tell him what you think about him protecting people that hurt kids and not protecting kids, to that effect. So the call to action was in the television commercial, aired in the last 2 months of Superintendent Horn's office as superintendent. So really the message was the state superintendent is protecting people that harm kids, not protecting kids. So it was really a message, send a message to Tom Horn about what you think of that. And that those words, call this candidate, that's commonly used just to avoid the magic words.
Let me ask you about the period. You said that they ran for a couple of months before the election. I believe that
That's not what she said.
That-
She said a couple of months before his term as public superintendent ended.
because I wanted to get to the issue of the period of the campaign, the period of the running of the advertisements. I believe that the record reflects that the advertisements began running in October of 2010.
Yes, Judge Jones, that's
The
correct.
election, the general election, was in the first week of November of 2010, I believe.
November 2nd, yes.
That is in the first week, thank you. I thought it was a little later than that, but November 2nd works. So they ran for a period of a couple of weeks or a few weeks before the election?
That's correct.
How long did they run after the election?
We have no information that would show that any ads were run after the election. I guess that's the catch-22. Without the disclosure being given, we don't have much information on what the so-called flight times or how frequently the ads ran.
You don't know what the term of the contract was for the provision of the airtime?
That's correct.
Thank you. Go ahead.
The context of the ad also portrayed Mr. Horn in a very unfavorable light. It talked about his voting for legislation that reduced the penalties for statutory rape, and that action was taken actually 10 years prior to the election. It was in the year 2000. And the other part of the ad refers to a teacher watching child porn in a classroom and then voting to reinstate that teacher. So the clear implication of the ad is Mr. Horn wasn't protecting kids, he's protecting these people that are hurting kids. So the call to action is essentially to send a message to Tom Horn based on that information. So the standard of review of that evidence for the appeal of an administrative hearing and judicial review, an appeal of a judicial review, is whether the county attorney had sufficient evidence to make the determination to initiate enforcement.
And just so I'm clear, when I understand your position as this indeed was express advocacy. Is it your contention it's express advocacy under 16901A2?
Under the 16-week period as well?
No, under A2, making a general public communication, targeting the electorate of that candidate in context has no other reasonable meaning to advocate the election or defeat of the candidate as evidenced by factors such as that section.
Yes, Judge Winthrop, that's correct.
All right.
So it's express advocacy under A2, both Part A and Part B, because it did run in the 16-week period prior to the general election.
But subsection B's been changed since then.
That's correct. It has.
What if the ad had run in April? Would this still be political express advocacy?
Judge Orozco, that could be the case of whether it would be express advocacy. It would depend on, in that case, more of the timing issue. So the timing being further away from the election, it certainly wouldn't fall within a 16-week provision.
But at that time, he was running against, I believe, Andrew Thomas, or in the primary election.
Yes, that's correct. So the primary election would have been at the very end of August of 2010.
So would that have been, in your analysis, would that have been an express advocacy? Because there was maybe it wasn't, let's say it was within that 16-week period. Let's say that it was in June. Would that have been an express advocacy?
Well, actually, the 16-week period would have fallen somewhere in mid-July.
Okay.
And yes, indeed, that would then be express advocacy because in Arizona's electoral scheme, early voting starts about 4 weeks prior to the election. So the sixth week out would have been just before early voting had started. Therefore, there was substantial evidence for the county attorney to initiate enforcement action. The Appellee Committee for Justice and Fairness say that this is not express advocacy and that it's overly broad. And to be overly broad, there must be a substantial number of applications showing that the law is unconstitutional. And Committee for Justice and Fairness has not shown any applications. Also, they allege that it will have a chilling effect on speech because of the donors being afraid of harassment, retaliation for contributing to this campaign. However, there's been no evidence offered that it would be, the donors would be subject to harassment or there would be a chilling effect. Also, the case is distinguishable from the Wisconsin Right to Life case. In that case, that dealt with the limits on contributions to, expenditures by corporations and labor unions. And that was an as-applied challenge and did not apply to disclosure requirements. And the footnote with that four-part test, that in fact was not the holding in the case. The holding was The functional equivalent test is when the ad is susceptible to no other meaning, no other reasonable interpretation than to appeal for a vote for or against a candidate. So very similar to the express advocacy definition that Arizona used, ARS 16901.01b. And I would like to reserve the remainder of my time for rebuttal.
Can you very quickly address the issue, because I want both counsel to address this, can you very quickly address the issue of how we got to the court's determination that portions of the statute were unconstitutional without telling us how it was they were unconstitutional?
Judge Jones, I'm not exactly sure how the trial court judge reached his decision. He, in one or two sentences, just said he adopted the reasoning of the Committee for Justice and Fairness and, in fact, declared a number of statutes unconstitutional. But how we reached that, I'm not sure.
Without delineating what portion of what argument might have been the basis for the determination?
That's correct.
Thank you.
Thank you.
Good morning. May it please the court, I'm Tom Irvin, representing the appellee, and here and in the trial court. The issue here in terms of whether or not the actions of the regulator limit speech, absolutely the actions of the regulator limit speech, because we know from Citizens United and from the Massachusetts Citizens for Life case that it's a limitation on speech to require somebody to form another entity and to dive in to the governmental regulatory system. So here, CJF was an entity, a 527 under federal law, and the state's position is that another entity has to be formed, namely an Arizona political committee. And that is a infringement upon speech. And in fact,
Mr. Irvin, can I ask you something about the speech issue here? I certainly understand your position that the First Amendment applies to a speaker as they want to express something. Doesn't the First Amendment also create some rights in a listener?
well, Judge Winthrop, yes, a listener has rights, but that's not the issue
But
here.
and part of that isn't part of a right, the First Amendment rights enjoyed by listeners to understand the source of the speech that's being proposed and the context in which it's being offered?
Judge Winthrop, I think absolutely not. That is a matter of constitutional regulation. The regulation has to be constitutional. And all of these cases going back to Buckley are about what is the limit, what is the proper limit on the regulation. And to say that, well, we're going to require anybody who talks about politics to register with the government and file reports. Well, that would clearly be unconstitutional. And that's what's happened in the last decade with the Roberts Court. Clearly it's been a step back from McConnell. In fact, the Citizens United overruled part of McConnell and overruled Austin. So what we have, and if we go back to Buckley used strict scrutiny. The Massachusetts case used strict scrutiny. Bellotti used strict scrutiny. When it's like Arizona. The Arizona, it's what's the difference between Arizona and the feds, and Colorado for that matter, is we don't have electioneering communication. We don't have political, we have political organizations. We have one pathway. When do you have to move into the regulatory system? You have to move into the regulatory system under 901.19, political organization includes an independent expenditure. Then, after we finish with 901.19, we go to see what's an independent expenditure. That's in 901.14, and that's express advocacy. Then we go to 901.01 to see what express advocacy is. So the trigger, the doorway into regulation is speech. That's why it's strict scrutiny. That's why the Wisconsin case applies and the Colorado case applies, because what we're analyzing to see whether we walk through the door to regulation is speech. And there is no right to know, like, did somebody, pay me to say that? There's no right to do that. That's a matter of regulation that has to be constitutional. And here, we're analyzing speech
But
to decide the doorway.
If in fact, for argument's sake, this ad did constitute express advocacy, then the listener would in fact have the right to know the context in which it's being offered, who's paying for it, and so the listener can then evaluate, have a full understanding and evaluate the speech.
Your Honor, if we had a constitutional definition of express advocacy, absolutely. What happens in a case like this is you have to then look at the speaker. The speaker has to know when that line is being crossed. And here we are in the fourth year after the 2010 election, still trying to figure out, has the line been crossed? That's completely impermissible under the First Amendment. You have to know before you speak. So as my client was speaking, made an intelligent, rational judgment that this is not express advocacy, because there's these Supreme Court cases out there, there's other things out there, they're not using magic words, they're not talking about the election, they're not talking about a candidate by name and office. They're doing exactly what the Wisconsin case did. That was a Wisconsin case, exactly. And if you look at the Wisconsin case, what is the issue there? The issue is, what is express advocacy? And there was no mention of an office. There was a mention of filibusters. And that's identical to the conduct in 2010.
So, and I understand your position. Your position is that your client's position. This was merely issue-related advocacy.
Yes, sir.
And the issue was protecting children in some fashion.
Yes.
And you think the ad fairly identifies Mr. Horn as having voted against an amendment to a statute that would have created greater protection for children.
That's what the ad did, Your Honor.
All right.
Yes.
Why did if that's the case, my understanding is that the particular legislation failed in the committee of the whole by a vote of 40-12. Wouldn't your argument have more impact if the advertisement in fact listed the other 40 legislators who voted against that bill?
Well, the other 40 legislators were not occupying the office of superintendent of public instruction. So a speaker can make that kind of a judgment, because many of them were out of office, never to come back into office. Nobody was in a statewide office dealing with children. So that's the speaker's judgment, not a government's judgment. And here, just like in the filibuster case in Wisconsin, the ads talked about filibuster. It didn't talk about re-election to the United States Senate. Didn't talk about the office the person was running for. It just talked about filibusters. And that was found not to be express advocacy, just like this is not express advocacy. The Colorado ethics case is much closer, because those ads actually talked about the office people were running for, talked about their positions on issues, and talked about what they were doing, and found that was not express advocacy. So the issue here, to get to your question, Judge Winthrop, is that you have to get into the broad factors of A2. And the broad factors of A2, there is not one case in this country that upholds that kind of analysis looking at the broad factors, including Cromco. And Cromco is actually a wonderful case, because it predates Wisconsin right to life, and it is exactly the same as Wisconsin right to life. It has to be an unambiguous statement with an unambiguous call to action.
Are you familiar with the Fergatch case out of
Yes.
the Ninth Circuit?
Yes.
Does that not seem to be closer on point than some of the other authorities you're citing?
Judge Winthrop, Fergatch has been is probably the most discredited case in the Buckley line in the last 30 years. And Fergatch has not been adopted in Arizona. In fact, Cromco explicitly did not adopt it. And Cromco cited the Schroeder case in California from the California Court of Appeals that explicitly did not adopt Cromco. So, did not adopt Fergatch. And the recent case of Bumsicle in the Ninth Circuit goes through and details the Ninth Circuit's back and forth on strict scrutiny and explains that, and doesn't even mention Fergatch. It starts with Getman, which is in 2002. So I think even the Ninth Circuit's most recent statement on this does not go back as far as Fergatch, because Fergatch is just not good law, especially not good law after Wisconsin.
Well, maybe I missed it, but I didn't see that Fergatch had either been overruled or taken up on cert and reversed. So as far as I know, it's still on the books.
Judge Winthrop, just forgetting about it, as in Bumsicle, you don't have to overrule it if you just forget about it. And that's what Bumsicle did. It just goes back to Getman in 2002 and doesn't get back to Fergatch before that, and is just forgetting about it. But explicitly in Arizona, in the Cromco case, rejected Fergatch. So Fergatch was not the law of Arizona in 1998. Arizona adopted in the Clean Elections Act, adopted an act to cure politics, and has a definition that has not withstood the test of time because it does not meet the standard of Wisconsin and the later decisions that have come about. But going back to the beginning is how, as you decide this case, how would my client know whether it's express advocacy? How? If we look at these broad factors that, look at this, look at that, or as the state has been saying and the administrative law judge said, how would, it's just, we know it when we see it. We just know it when we see it. Well, that's not a constitutional standard. And to go to Judge Jones's question about what did the trial court do, I think we, in our papers in front to the trial court, had enunciated the standards, and the trial court said, for the reasons stated in those papers. And they're basically the same reasons we provided to you, which is Wisconsin and Colorado ethics, and that's an appropriate way for the trial court to rule.
But are you then saying, speaking of forgetting about it, are you then suggesting that we have to forget about the second part of 16901.01, where it talks about the fact that it would also be express advocacy for campaign slogan or words that in context can have no reasonable meaning other than to advocate the election or defeat of one or more clearly identified candidates? You don't have to specifically say Tom Horn. You don't have to specifically say he's going to run for the state attorney general, do you? Under 16901.01 A1, the last sentence? That's still express advocacy, correct?
Judge Jones, under the definition in the statute, it is, but it's unconstitutional. And it's unconstitutional because of, just look at the Cromco test. Express advocacy may be based on communications that, taken as a whole, unambiguously urges a person to vote in a particular manner and must clearly and unmistakably present a plea to action and identify the advocated action. Well, that standard of broad context doesn't do that. So this state has adopted the Cromco standard in 2002. So as my client was sitting there in 2010 saying, well, do we have to form this entity and dive into this complex system? And we respectfully disagree with the state's position on the complexity of the system. If you look at the system described in Citizens United, Arizona's system is much more complicated, especially when we take the Clean Elections brief into account, where they talk about daily reports. There's no daily reports in Citizens United. There's almost minute-by-minute reports in Clean Elections, and it's way more complicated than what Citizens United found to be a denial of a right to speech. And so
your client has organized itself as a political organization. Are you really saying that this is beyond its realm of understanding as to how to comply?
Well, Judge Winthrop, absolutely not. My client has what Citizens United says should not be required. They've got legions of lawyers. They've got accountants. They've got experts. They've got all that. And they still apparently guessed wrong under Arizona, because here we are 4 years later.
Well, my point was they know how to do it.
Yes.
If they conclude that they have to.
If it was clear that they have to, Judge Winthrop, that's the issue, is that when it's First Amendment, you can't guess at the threshold. What is the trigger? Well, what is the trigger? Well, we're still here talking about what is the trigger. And the trigger, if you take the portion of the statute Judge Jones read, is it can't be that, because both Cromco and Wisconsin say that, first off, this is very, very clear in Justice Roberts' opinion, that there has to be a bright line test. A bright line test. So is that second sentence in A1 a bright line test? No. No. Only after the bright line test do you get to the four factors that are limiting, very limiting of what can be considered in context. But so is that second sentence a bright line test? Is A2A a bright line test? No reasonable meaning other than? Of course not. They're not bright line tests. So they don't meet the first standard of Wisconsin, and they absolutely don't meet Wisconsin or Cromco, because they're not unambiguous call to action for specific action about voting. So we don't see the ability for this statute to be unconstitutional. And what the trial court did was very surgically remove the unconstitutional pieces of 90101. And what, in a sense, you're being asked to do is to do what the Supreme Court did in Buckley, which probably started this whole mess in the 70s, which is, instead of reading the statute for what it was, they said, well, first off, let's narrow this up. Let's read this. The only way it's constitutional is let's pretend it's magic words. And once they narrowed it to the magic words, they found it unconstitutional anyway. But they narrowed it up. And that's legislating. So what parts of the statute are you going to narrow up that second sentence of A1? Are you going to narrow up A2A? Or just say, well, that's for the legislature? Because Arizona does not have electioneering communications. The legislature could adopt that and solve a lot of these problems. Electioneering communications is a simpler form of registration, a simpler form of reporting, and there's cases all over America about what is constitutional in adopting that. But that's a legislative decision.
You know, having done these reports as the county attorney, and having done them myself, they're really not all that complicated. And that I think that anybody, I truly believe anybody could do them. And it doesn't take a lawyer. But my question to you is assuming that we find 901.01 constitutional, especially the second part that we've been talking about, how do you explain these ads running 2 weeks before a campaign, before the election, less than 3 months before Mr. Horn is to be out of that office? How do you explain that that is not what do they call it, an advocacy for the election or defeat of Mr. Horn? I mean, look at it. It's done 2 weeks before the campaign. It's done with the 2.5 months before he's to vacate that office. I mean, for all intents and purposes, in that office, he's a lame duck. And how is that not, how can we not give that a reasonable meaning other than to advocate for his defeat?
Well, Judge Roscoe, I think you just follow what the U.S. Supreme Court says. Starting with Buckley, issue advocacy cannot be regulated. And so this is issue advocacy, no matter how close to an election. And then when we come to the Wisconsin case, Justice Roberts' opinion says the proximity to an election cannot be a factor. The fact that it has an impact on election cannot be a factor. And that the statute just doesn't make it clear if it's issue advocacy. So you could say that, boy, that's wonderful. You can say, boy, that's bad. But it's issue advocacy. There is no bright line test in the statute. And looking at factors that the U.S. Supreme Court has declared to be impermissible is how you do it, is how you say that it's that it is a permissible act by my client. And looking at the context of it in the broad sense of saying, oh, there's an election and here's how people will hear it. One of the most compelling parts of Justice Roberts' opinion is his denunciation of the notion that you look into the mind of the hearer. Because if you look into the mind of the hearer, that means that, as he said, that one speech listened to by one person could be express advocacy and heard by another person could not be, because they would take it differently. And we can't look at the hearer. It's just not a permissible factor under the law, even though it makes sense. But it makes sense in an unconstitutional way when we dive into this pile of opinions, all of which are 100 to 200 pages long, and we can't get there.
And that was the question I was going to ask, because I just can't remember. What was the Wisconsin case and Robert's opinion? Was that portion of it, was that a plurality opinion?
Yes, Judge Winthrop. The interesting part of it, though, as we pointed out in footnotes in two of our filings, was that it was a plurality, but the Scalia dissent had another 3 or 4 justices on it, and those 3 or 4 justices said, none of this reasonable stuff, magic words only. So that's why, as we point out in our footnotes, that the Roberts bright line and 4 factors is the most expansive version, because we're one justice shy of saying magic words only based on Wisconsin.
Based on Wisconsin.
Wisconsin.
But isn't that the same case that says that don't they use the standard of no reasonable interpretation can be given other than an appeal to the voter for or against a specific candidate? Isn't that part of their determination in that case? Their review?
Judge Jones, that is in the Roberts plurality. But Justice Scalia's concurrence says, hey, we're concurring in the result, but we think it's magic words only. None of this reasonable stuff. So that's why the Wisconsin test is barely survived.
Thank you.
Thank you.
I'd like to first start with the standard overview. The appellees argue that strict scrutiny applies, and in the disclosure context, that is just not the case. It's the exacting scrutiny test that's very specific and consistent throughout the disclosure cases. So there has to be a sufficiently important governmental interest that's substantially related to the disclosure. And here, the important governmental interest is to make sure the voters know who the speakers are, who's paying for these ads, who are the political committees that are behind these other political committees with clever names, like the Committee for Justice and Fairness. The real source of the money is the Democratic Attorney General's Association. And the case law goes into other examples of committees with names that really don't reveal the source of the funding, like Citizens for Better Medicare. That one doesn't suggest who paid for the independent expenditures, and it sounds like a grassroots organization when it turned out to be the big pharmaceutical companies. The express advocacy test, just by using the magic words, is the easiest test to avoid. Just stay away from the 11 phrases that are used, and then you can say all the bad things or all the great things you want about a candidate.
What other cases address the issue of the reasonable interpretation? No reasonable interpretation can be given other than an appeal to vote for or against a specific candidate. There's Wisconsin right to life, and council says, okay, but that's a plurality. We have it certainly, that's the second sentence we've been referring to so much in 16901.01, that they want determined to be unconstitutional. Is there any other authority that recognizes that as acceptable?
In the Wisconsin Right to Life, Judge Jones, that case dealt with the limitation on corporations and labor unions from spending. So it was whether it was express advocacy or the functional equivalent of express advocacy. After that, there was the Citizens United case, which in the disclosure portion rejected the Wisconsin Right to Life holding in the sense that it was not applicable to the disclosure requirements, the 30-day window before the election, the 60 days before the election. But as far as other circuits, there is the Madigan case, Center for Integrity v. Madigan. I have to grab. Yes, the Center for Individual Freedom v. Madigan, that's a Seventh Circuit case, just decided in 2012, and that's cited in the appellant's brief. So the reasonable meaning of the ad allows for a common sense approach to these ads that, as suggested in McConnell, the distinction, the bright line test is neat in theory, but it's not workable because people just avoid the 11 words or phrases and they can say anything they want. They say anything they want and they can do it in secret. The public doesn't know who's funding the ads. Therefore, the county attorney's office respectfully requests this court reverse the decision of the trial court and affirm the decision of the county attorney.
Okay. Thank you. Thank you very much for your argument. We will take this matter under advisement and issue an order in due course. Thank you both very much for your arguments, and we will adjourn.